Welcome back. Today, Senator John Kennedy went full bulldog on a Judiciary Committee nominee. The questions got real fast, covering Chevron, Loper Bright, and even asking if the nominee would ignore a federal judge. Let's break it down. You don't want to miss this. Let's start with the Loper Bright case, the Supreme Court decision that just obliterated the Chevron doctrine. For 40 years, courts gave federal agencies a thumb on the scale when interpreting vague laws. That was Chevron. Loper Bright said nope, not anymore. Now courts decide what laws mean from scratch. Agencies don't get that head start. Loper Bright changed the game.
Tell me about the Loper Bright case.
Sure. So Loper Bright is the case that overruled the Chevron doctrine. And the Chevron doctrine originally required that if there is an agency statute that governs an agency's conduct, the agency gets deference, meaning a thumb on the scale, when it's interpreting what that statute might mean as it's carrying out its duties. Loper Bright determined that that framework was inconsistent with the Administrative Procedures Act, and instead that moving forward, courts should decide all of those statutory interpretation cases as a de novo matter, meaning the agency doesn't get any sort of special head start.
Then it got more layered. Kennedy dug into how Loper Bright interacts with West Virginia v. EPA. West Virginia didn't fully kill Chevron, but made it harder for agencies to act without clear congressional authority. But Loper Bright overruled Chevron entirely. So do we still need the Major Questions Doctrine? Yes, because courts still need guidance on reading ambiguous laws.
What's the relationship, if any, between Loper Bright and West Virginia v. EPA?
So that's a fascinating question. I think, West Virginia versus EPA applied Chevron, but said we're less likely to find ambiguity, and indeed Congress needs to speak clearly if the agency is purporting to resolve a matter of, in the court's terms, political or social significance. And following Loper Bright, of course, there is no deference. And I think some have commented, including Justice Barrett, that the best way to think about West Virginia versus EPA in interpreting statutes is that it informs the context of how we understand what the statutory terms mean in the context of an agency delegation. So the fact that the agency is purporting to carry out its duties might resolve whether or not the particular question is sufficiently clearly delegated by Congress.
That just seems to me like a distinction without a difference. I mean, doesn't Loper Bright wipe out the need for West Virginia v. EPA? Why do we still need a Major Questions Doctrine?
So it's certainly true that West Virginia versus EPA, I think, was partially driven by non-delegation doctrine concerns and concerns about deferring to agencies when doing so threatened our separation of powers. After Chevron has been overruled, of course, that might be relevant in a smaller number of cases, but I do think that the Major Questions Doctrine still has vitality in understanding the best meaning of the statute as Loper Bright now requires.
Now we're getting into the weeds. Kennedy brought up the Public Rights Doctrine, and if your eyes are glazing over, stick with me. Courts split rights into private, like contracts and property, and public, like Social Security or immigration. The Supreme Court's Jarkissi ruling said some SEC actions look too much like private rights, so they need a jury. That's a massive blow to agency power, and Kennedy made sure to highlight this shift.
What's the Public Rights Doctrine?
So most recently, the Public Rights Doctrine has been applied in the Seventh Amendment context, and the Supreme Court has a decision named Jarkissi, where there's a line of precedent saying that if a matter involves public rights, so the conferral of a public benefit, for example, that might be the type of matter that Congress can vest adjudication of in Article I tribunal or in an administrative agency.
What's a public right?
That's a very difficult question to answer in many cases.
That's why I'm asking you.
Yeah, so I think the best way to think about it is to contrast it with private rights. And what the Supreme Court has instructed with respect to private rights is that they're what we would think of as common law type claims. So contracts, property, torts, the stuff of Westminster in the court's terms. And so if you have a matter like that, That's the type of matter that needs to go before a jury to ensure that the Seventh Amendment's jury protections are abided. By contrast, if there's an internal administrative process, Social Security benefits, things like that, that looks more like a public right that wouldn't have existed but for the government granting it.
And what did the Supreme Court hold in, was it Jarkissi?
That's right.
What did the Supreme Court hold?
So the Supreme Court there held that certain matters of the Securities and Exchange Commission actually looked more like common law fraud claims and more like property-based claims that must be tried to a jury in court and cannot be vested in the in-house SEC proceedings to be tried before an administrative tribunal.
Kennedy dropped a bombshell. If your client loses, can you ever tell them to ignore a judge's order? The nominee danced around, citing hypotheticals. Kennedy cut him off. I'd be real careful. Classic Kennedy, blunt, direct, effective.
District court rules in a case. You got plaintiff or defendant, and defendant. You're representing the plaintiff. Your plaintiff is very unhappy. Are there any circumstances under which you would advise the plaintiff to ignore the federal court order?
So, of course, as a judicial nominee, I would be trying to issue proper orders.
I don't want to split hairs here.
No, the normal process is to
I know what the
seek
normal
appellate
process
review.
is. Can you
Right.
think of any circumstances where you would tell the plaintiff, nope, you don't pay attention to this federal judge?
So the problem with answering it that categorically is that there are potentially some very extraordinary situations you could imagine. It's a subject of tremendous
careful.
scholarly.
This hearing was a crash course in how courts are shifting the balance of power between Congress, agencies, and the Constitution. Loper Bright is a huge legal moment. West Virginia v. EPA is still in play. And the Public Rights Doctrine? That's the next frontier. See you in the next one.